This is a video on how to write a better bar essay by Fordham. We're going to start with a bunch of boats. They're pretty boats, but they're all mixed up. They're all kind of in each other's way, just kind of like a bar essay would be, where you get a bunch of facts and you're being asked to take those beautiful facts and put them into something that makes sense. So for this video, we're going to talk about bar essay number 2, which, if you're not in my class or Professor Dooley's class, probably means nothing to you. In any case, let me go over the facts. Okay, it starts off in a cold, dark place. Tenant, aptly named, lives in landlord's apartment building. The furnace in the building was inoperable during 3 periods last winter, causing the loss of heat and hot water. On each of these occasions, the landlord made temporary repairs. Brr. On March 25th, it broke down again. Landlord was promptly notified of the problem, and he ordered the parts needed to fix the furnace on March 26th, which is the very next day. But they didn't arrive until April 6th. Can you say next day mail? At which time landlord fixed the furnace. Between the time of March 25th and April 5th, there was no heat or hot water in the building. And of course, there's a law. State statute in the relevant jurisdiction provides that every apartment building and every part thereof shall be kept in good repair. The owner shall be responsible for compliance. A violation shall be punishable by a fine not exceeding $500. When you see a statute in a torts fact scenario, you think negligence per se. Okay, part 2. The story. Tenant wanted to bathe while he was in the cold water, or without warm water. So from March 25th through April 5th, tenant heated a large pot of bottled water on the stove. After the water boiled, tenant transferred the water to the bathtub, mixed in some cold waters, and then used the water to bathe. Gotta tell you, that's a lot of trips from the kitchen to the bathtub, from the kitchen to the bathtub. It's faster, just move the bathtub to the kitchen. Okay, now the sad part of the story. On April 3rd, nephew, who had many misfortunes, including a name that is not very original, tenant's 8-year-old nephew, arrived for a visit. On April 4th, tenant was carrying a pot of boiling water down the hall to the bathroom when nephew, who was chasing a ball out of the bedroom that opened in the hall, collided with tenant. Screams, yells, ouch! As a result of the collision, the hot water spilled on nephew, seriously burning him. Nephew did not look or call out before running into the hallway. Now, what happens next? Of course, a lawsuit. Nephew, by his guardian, sued tenant and landlord for damages. At trial, both tenant and landlord argued, hey, it's all nephew's fault. The sole cause of the action was the fault of nephew. And of course, the question. The question asks you, based on these facts, may the jury properly award nephew damages for his personal injury? From tenant, explain. From landlord, explain. Okay, so that sets us up for writing the bar essay. Before we dive into the details, though, I want to give you some general tips about writing bar essays, and this one in particular. First off, getting organized. Look at that. There's a clear path that tells you exactly where you're going to go. That's what you want your essay to look like. You want the bar grader to pick it up and in the first moment they see it say, oh, I know right where they're going. You do not want them to have to fish around between the trees and in the mud and in the weeds. You want them to know this is where we're going. So take a look at this hypothetical essay response. It's got a lot of really good ideas in it, and it has some really appropriate rules in it, and it has some good analysis and facts in it. But would you really want to read that? Does it really help you? Not so much. It's kind of a mess. Well, let me give you another example. This one's a bit more common. It's what I call the matzo ball in the middle essay, where all of the issues are stuck up at the top, then all the rules are put in there, then all the analysis is crammed in together, usually in one paragraph, maybe two, and then all the conclusions are put at the bottom. So basically it's a giant IRAC. That's an improvement on the previous, but it's still painful because you'll notice that it's kind of hard to keep track of which rule you're analyzing when, which facts matter to what conclusions, and it's just kind of messy. Now look at this. This is a thing of beauty. It starts with an umbrella rule. Then it goes issue 1. It gives you the general rule for that issue and any exceptions. Then it analyzes that issue by combining facts, law, and reasoning. Then it gives a conclusion for issue 1. Notice that issue 2, issue 3, issue 4 are not even mentioned yet. Then you go on to issue 2, same story. General rule for issue 2. Any exceptions. Analysis of issue 2, combining facts and law and reasoning. Then conclusion for issue 2. And it goes on like this for each separate issue. Now, aside from being a lot easier to comprehend and a lot better organized, look at it. It just looks a lot more organized. And it's a lot more palatable to someone who's about to read 500 essays if the essays look like this. So you want your bar grader to be in a good mood? Make it look more like this. Okay, so you've written essays about different tort claims, and they all have a distinct pattern that hopefully you're learning to follow. First, you say plaintiff versus the defendant. First step is always to identify who is suing whom, and you want to go through the prima facie case of the plaintiff's claim against the defendant. So you'll have a general rule, which will be the elements of the cause of action. Then you'll have the first element, and you'll give the rules for that element, and now analyze it, and give a conclusion. Then you'll go on to element number 2, same story, give the rules for element number 2, analysis of element number 2, conclusion. Same with 3. Now, the defendant is probably within each of these rules and analysis saying, hey wait, but you know what? It's not my fault. Or hey wait, that element isn't really established. Well, that element is an established argument, is a good argument to put in the prima facie case. But the, okay, yeah, I did it, but it's not my fault argument, that's an affirmative defense. You want to save that for the very end. Because then it's essentially the defendant saying, okay, even if everything you say is true, even if all of those elements are met, I'm still not liable. So let's change this a little bit to not looking just at tort claims, but looking at negligence claims. Okay, do they look any different? A little bit. Again, we start with plaintiff versus defendant. Then we have an umbrella rule, which lists the 5 elements of cause of action for negligence. Then you start, your first issue is going to be, guess what? The first element, duty. You'll have the relevant rules for duty. You don't need to list every possible rule for duty and every exception. You want to put in the rules that you're going to use. You do some analysis and reach a conclusion about duty. Then what do? Well, you go on to your next issue, which is breach of duty. Now, in bar essays, I would recommend that these elements, especially on negligence, where the elements are big, you want to make each one of these a heading. So you'd give the relevant rules for the standard that the defendant is going to be held to. And if it's not sure whether it's an adult standard or a child standard, you might need to do some analysis and give some extra rules on that. Otherwise, if it's just a reasonable person, then you don't need to do extra analysis there. Then you go in and analyze breach. Sometimes there's a relevant rule for breach, like if you're doing res ipsa loquitur or negligence per se. Some people even use a rule when they do a hand analysis, though I think it's not necessary. And then you analyze and reach a conclusion as to whether the standard was breached. Okay, now can you guess what the next issue is going to be? Cause and fact. And so you give the rules for cause and fact and analyze those, reach a conclusion. Same thing with proximate cause, same thing with damages. Now, I haven't brought up contributory negligence yet, and there's a good reason for that. That's because it's an affirmative defense. Contributory negligence, you want to save for the very end, just like dessert. Give the relevant rules for the standard that the plaintiff is going to be held to, because as you'll recall, contributory negligence is saying, okay, even if the defendant was negligent, the plaintiff was negligent too, so the plaintiff should not win or should not get as much in damages. Then you do analysis and conclusion regarding whether the standard was breached by the plaintiff. Okay, so that's your basic structure for negligence. It's a lot to get through. I recommend that you have the structure already in your mind. You have the rules already memorized, and so all you have to do is sit down, write down your beautiful headings, beautiful rules, and do some great analysis. So let's look at the particular negligence claim that we're dealing with in this fact scenario. So, of course, we're going to start with plaintiff versus defendant. Here we've got two. Let's start with nephew versus tenant. Why not start with nephew versus landlord? I'll tell you. Because in the bar essay, it says 1 period, nephew v. tenant, where it asks about his claims against the tenant. So you want to always go in the order that they set forth for you to go in. If you go in a different order, they'll get all confused and you'll lose points. You don't want to lose points. So we start with nephew versus tenant, and then we're going to give our umbrella rule, which is the elements of negligence. Then, can you guess what we're going to do? Yes, we're going to go to the first element of a cause of action for negligence, which is duty. And we're going to analyze that. So first we'll give the relevant rules regarding duty. Again, you don't need to give every rule on the face of the earth regarding duty. You just want to give the ones that are relevant. Then you want to analyze whether there's duty and reach a conclusion. Now, usually the duty analysis is pretty quick because usually there's a duty by one means or another. The only times it gets a little bit longer will be if it's unclear if something was an affirmative act or not. Somebody said something, goaded somebody to do something. Another time is when it's a special relationship. There can be a little bit of back and forth on did they owe a duty to this particular person. But usually duty is going to be pretty quick and clean. Next, you go on to breach of duty. First thing you want to do is you want to give the relevant standard for breach of duty. This is where you would talk about the standard that tenant is going to be held to. And you always want to give the general rule before you give any exceptions. Here, we don't really have an exception. Then you want to go into analysis and conclusion of whether the tenant breached the standard of care. Alright, so for this bar essay, you were not supposed to go on and do all 5 elements of negligence, thank goodness, because there wasn't time. Although in the future you will get that opportunity. So we're just going to leave it at those 2 elements, and we're going to move on and go on to nephew versus the landlord, because that's number 2. And now, we could do the exact same thing we just did with the tenant and put in duty and analyze breach next. But since we know that there's a statute in the fact scenario, it might be a good idea to instead start with negligence per se. In fact, it's not just a good idea, it's something you should do. So, you're going to analyze negligence per se. First, by giving the rule for negligence per se, and then do an analysis of negligence per se. Now, if you find that negligence per se doesn't apply, which actually probably doesn't in this case, you would want to go on and do duty and breach, but you wouldn't have time, because you still need to get to something else that's very important, which is contributory negligence. So if you did go on and do duty and breach, that's okay, you got points for it, but you need to make sure you get to contributory negligence. So contributory negligence, we're going to give the relevant rule for the standard that the nephew is going to be held to. Then we're going to analyze and reach a conclusion as to whether that standard was breached. And then we're going to all breathe a big sigh of release because you just got finished and you have 10 seconds to spare to fix spelling errors and things like that. So that's how you should organize this claim. Once again, I recommend that everything you see on the screen that is in black should be in a heading so that it's easy for the reader to see right up front how you're going to organize it. Other thing to note is all the rules aren't put together and all the analysis isn't a matzo ball in the middle. We've broken it down so the relevant rules for duty are with duty, the relevant rules for breach are with breach, and the analysis is separated not only by person but also by element. Okay, now every essay needs a solid foundation. The foundation for your essay are the rules. And there's some tricks to using rules effectively. There's actually a pattern that most rules follow. And if you miss part of this pattern, you often miss much of the much of the analysis. Some students try to do analysis and skip over the rules because they know the rule isn't as worth as many points as the analysis. The problem with that is they inevitably get the analysis wrong and it gets confusing. So you gotta know the rules, state the rules. So there's a general pattern, as I say. First, there's usually a general rule. Then there's a more specific rule or an exception to the general rule that modifies the general rule. And then sometimes there's a definition or explanation. Not every rule has all these, but you want to think about which ones do and don't. So for example, your general rule might be the nonfeasance rule, that there's no duty to take affirmative action for the benefit of others. Do we have exceptions to that rule? You bet. One exception might be special relationships. When one has a special relationship with another, one has a duty to use reasonable care to prevent harm to the other and to prevent the other from harming third parties. Well, now, we haven't defined what a special relationship is. So that's something else you'd want to put in. Special relationship exists when one party exercises sufficient control over another to impose a duty of reasonable care. Now, you don't need to put down general rule, specific rule definitions. You just need to put down all three of those parts of your rule so that you can parallel that in your analysis and have all of those three parts in your analysis. Let's try another one. Okay, general rule. A person acts negligently if the person does not exercise reasonable care under the circumstances. That's the general reasonable person standard. Professionals, however, are held to the standard of other professionals in the same field and specialty. So we gave our general rule, and then we said, hey, but wait, professionals are held to this other rule. And you would want to do that if you're dealing with professionals. Here we don't really have a definition to add, but it's good to be aware that sometimes there is one. Okay, so now let's start going through the analysis. And as I go through this, I want you to look at your essay and see what you did and didn't do. First, just looking at it, looking at the page that you wrote, pages probably, did you organize it in a way that was clear? Was there that clear path down the middle? Did you use headings and organize it so that the reader knew from the very start exactly where you were going? If not, that's a great way to improve on your retake. Another question you can ask as we're going through these is, did you give the complete rule? And did you give the rule correctly? I see a lot of people giving partial rules or giving partially correct rules. Sometimes you can get away with that to some extent and not have it completely sink the ship, but you want to get it as right as possible, especially when you're not just looking to pass, but on the final exam when you're looking to prevail among others. Okay, so let's start with the first part of our essay journey, which is going to be nephew's claims against the tenant. First thing you want to do is have an umbrella rule, as we mentioned. The umbrella rule for negligence is the elements of negligence: duty, breach, cause and fact, proximate cause, and damages. Now, you could do this just by saying negligence requires duty, breach, cause and fact, proximate cause, and damages. It's a lot nicer if you can do it in a complete sentence, but it's a balance between time. You generally want to assume that the reader knows the facts but does not know the law, so it might be worth spending a little bit more time on the rule. Here, this is probably the most you would want to say. You could probably cut this down and be a little more concise. Okay, so you did the umbrella rule, and now we're going to dive into the first element of a cause of action for negligence, which is duty. There we have our pattern set out for us. The general rule here, in this case, there were several different ways of arguing that there was duty. The most obvious and the most likely means of duty is simply premises liability. If you're at, if the plaintiff is on somebody else's property, then it's likely that there's going to be premises liability. But you could also argue a special relationship because the uncle or aunt is in control of the nephew. Nephew's young enough. You could even argue an affirmative act. I'm going to go with premises liability because that's what was intended by the folks who wrote this bar essay. And I think that is the last one, if you will, to use in this essay. So, the general rule. A land occupier's duty to visitors on his land depends on the status of the visitor. That's your general rule, that land occupiers owe a duty, and that duty depends on the visitor. Okay. Next we have a definition, which is what a licensee is. A licensee is somebody who's there for social reasons rather than business purposes. There were some students who talked about invitees. No, nephew is not an invitee. Nephew is a licensee because nephew was not there on business. 8-year-olds have some important business. But this nephew wasn't. He was there just as a social guest or being watched. And then you have your more specific rule. A land occupier owes a duty to exercise reasonable care to avoid foreseeable harms to licensees. Okay, so you see the three kind of parts of that rule. Start with the general rule, then you have a definition, then you have a more specific rule. So here we have those same three sentences, now all in the form of a paragraph. So it looks more like what your rule would look like. As we go into the analysis, you want to link the analysis to your rules. So let me show you here. The first sentence talks about a land occupier's duty to visitors. Probably don't need to say that tenant was a land occupier, although you could. Then the next part says, when the visitor is an invited guest there for social reasons, the visitor is considered a licensee. So it might be a good idea for your first sentence of analysis to explain why you think nephew is a licensee. Boom, here, nephew was a licensee because he was tenant's household guest. Alright, so you could end there, but wait a second, you haven't said what duty is owed. It's kind of implied, and if somebody wanted to think about it, they could probably figure it out, but much better to write it down. So, this third sentence of the rule says that the duty owed to a licensee is to exercise reasonable care. So, here in your analysis, you want to say, therefore, tenant had a duty to exercise reasonable care to prevent harm to nephew. So you see, the way we set up the rule can be paralleled in the analysis, and you don't want to skip things that are in the rule and not talk about them in your analysis. So, that's it for duty. Next we move on to breach of duty. Okay, we're going to have a general rule, which you already saw earlier. A person acts negligently if the person does not exercise reasonable care under all of the circumstances. Now, maybe there's an exception, but tenant's not a professional. Tenant doesn't have superior faculties that we're aware of. Tenant isn't a child, it would appear. So we might not need an exception. Now you could add in something to show that you know stuff, like saying that this standard has been, whether the standard has been violated is a question for the jury. Or you could say something like this is an objective standard, or something like that, that just shows a little bit more knowledge. Again, not necessary for a 4, but good to know to start pushing up above 4 and get into the 5s. Okay, then we get into breach analysis. So our question here is, essentially, did tenant act reasonably when he took that big old bucket of boiling water and brought it down the hallway and ended up colliding with nephew? Notice here, we're not talking about whether nephew was reasonable. That's an important question, but we're not talking about that yet. We are saving that for the affirmative defense. Okay, so one way to approach this would be to say, hey, it's not reasonable. Carrying boiling water is very dangerous, especially when children are near. Okay, that's good, but you haven't really put the characters into this. You haven't really talked about the reasonable person standard. So let's try this. Tenant should have recognized that carrying boiling water is very dangerous, especially since he knew young nephew was near. So now you've taken that and you've put the people into it, but we still haven't gotten as far as talking about what's reasonable and what's not. Although you have a should have, which kind of makes it sound like that. A little bit better. A reasonable, prudent person would recognize that carrying a large pot of boiling water poses a high risk of serious burns if the water is spilled. Note the language there. High risk, serious burns. So you want to think about what the reasonably prudent person is going to be able to foresee. Now, we've left something out here, though. Before we were talking about children, and now we've left out the child being near, so we want to add in a sentence about that, too. Further, a reasonable prudent person would recognize that children act spontaneously and often run without being aware of potential dangers. I think any reasonable person who has spent any reasonable amount of time around any child knows that children are tend to run and not look where they're going. So we could stop there. We could say, therefore, tenant failed to use reasonable care. The problem with that is if we just stop there, you haven't really said, you've said, yeah, it wasn't a good idea, but you haven't compared it to anything. And really, negligence law is all about making comparisons. He did this. This was dangerous. But if that was the safest thing and the best way to do it, he wasn't negligent. So simply doing something that's risky isn't enough. It has to be unreasonably risky. So I'm going to erase that. And instead, we're going to move on and talk about what other options tenant had. Okay, so more breach analysis. Here talking about other options. Well, one way to approach this would be to say, okay, rather than boiling water, tenant could have used cold water to bathe. It's true, he could have. Or he could have insisted that nephew stay with his parents while the apartment was in disrepair. So now we're showing, okay, there were a couple of other options that the tenant could have taken. This is good. This is better than not giving any options at all. But it still isn't really comparing these options to the other one or saying whether one is better than the other. It's just saying there were other options. So, you want to talk about whether these options are burdensome. You could say rather than boiling water, tenant could have used cold water to bathe. This would have been safer, but it also would have been very burdensome, especially when it's cold. So what's nice about that is now you're talking about the benefits and the drawbacks. It's kind of like a hand analysis. In fact, it is a hand analysis. You're comparing the costs and the benefits there. But it kind of leaves us in a spot where I'm not sure we want to be, because then it makes it sound like, well, you know, it would have been really burdensome. So what else could he have done? Well, we probably want to give some other options. So, and this is giving lots of options here. Rather than boiling water, he could have used cold water, or he could have moved out of the apartment. The problem with both of these options is they would have been very burdensome. And you want to explain what's burdensome about it. Well, cold baths are not very effective, and moving into a hotel would be expensive. However, there's other options that he could have taken that would have reduced the risk of harm and been reasonable. He could have closed the bedroom door. He could have asked a nephew to stay at his parents while the apartment was in disrepair. Or he could have simply yelled out, "Watch out, nephew! I'm coming with a pot of boiling water." I'm not sure that final one would actually do any good, knowing the 8-year-olds that I know, but in theory, that would have been safer, and it would have been, even if the accident would have happened anyway, maybe that wouldn't quite reach the level of negligence. So, there is our analysis. So notice what we did. We talked about what a reasonable person knows, the risks that they foresee. Then we talked about other options. And we didn't just talk about the options, we also talked about the benefits and the burdens, and did a cost-benefit analysis of the various options, and ended up saying, well, you know, there were some less burdensome options that the tenant failed to take that would have been safer. Then you reach a conclusion. Now, you're not the jury, and so it might be tempting to say, the jury is going to have to sort this out. In my humble opinion, I think this should happen, but it's left up to the jury. You don't want to do that because it sounds like you're not a lawyer. And frankly, you want to sound like a lawyer. So you want to say what the jury is likely to do, even though you don't know for sure. Because if your client came to you, your client would want to have some sense of how much trouble they were in. I've also added on here that a little teaser saying, hey, I'm going to discuss contributory negligence below. In case the bar grader is expecting it to come right at the end of the first plaintiff versus defendant, this tells them, no, it's down lower. Again, you always want to give the bar graders a clear road to where you're going. Okay, now we go on to the second question, which is whether nephew is likely to prevail against landlord. Here, instead of doing duty and breach, we're going to dive right into negligence per se. So there we have it. Did T owe a duty to end, and was it breached through negligence per se? Negligence per se, as you'll recall, takes care of duty and breach. So if you can establish negligence per se, you don't have to worry about the duty and breach. Alright, so again, with the rule pattern. Here we're going to have a general rule, and we're going to have an exception. Under the majority rule for negligence per se, the unexcused violation of a statute establishes duty and breach if the plaintiff is a member of the class of persons the statute was intended to protect, and plaintiff suffered the kind of injury the statute was intended to prevent. That one sentence has a lot packed into it. That one sentence cannot be analyzed in one sentence. So you want to be careful to unpack it. So the first thing you'll see here is that rule talks about a violation of the statute. So you're going to have to look at, did the landlord violate the statute? You don't want to just assume he did. You don't want to just skip that. You want to make that part of your explanation, because that's how you show you understand it. You'll also notice that it talks about it being an unexcused violation. So you're going to want to spend some time talking about whether the violation was excused. So that's the second thing you got to make sure you have in there. Third thing, you need to analyze whether the plaintiff is a member of the class of persons the statute was intended to protect. Now, how are you supposed to know that? Well, basically, you have to look at the language of the statute and say, why do I think the legislature passed this statute? What were they trying to accomplish? Who were they trying to protect? And you make an argument that the statute was probably intended to protect these kinds of people, or people in this class of persons. I'm not talking about social class, I'm talking about groups of people. Anyway, okay, and then second, you're going to need to talk about, this is actually fourth, you're going to need to talk about whether plaintiff suffered the kind of injury the statute was intended to prevent. That's similar to the other one, except now we're not just looking whether the person is the one who is to be protected by the statute. We're looking at whether the type of harm they suffered is the type that the statute was intended to prevent. This is a way in which negligence law narrows down the use of negligence per se. And there's a reason for that. Negligence per se is a way of basically taking the case away from the jury. Because if somebody's negligent per se, then we don't have to have the jury look at it and say, well, this was reasonable, this was not reasonable, here are their options. Instead, a judge can just say, well, you violated the statute, it's not excused, the plaintiff's in the class, and the plaintiff suffered the kind of injuries, so we're done. That's really good for efficiency and getting through it quickly, but it's not so good if we want there to be community standards that are deciding whether somebody is liable or not. And so that's why negligence per se is carefully prescribed. Okay. Now, there's an exception. And impressively, a lot of people saw this exception, though not everyone did. A statute cannot be used to support negligence per se if the statute itself is too vague, if it fails to provide a specific standard identifying the conduct that is to be prohibited. Because once again, remember, when we're doing negligence per se, when we're using negligence per se, we are doing it in lieu of the reasonable person standard. And so if the statute is just as vague as a reasonable person standard, then why use the statute? Let's use the reasonable person standard and have a jury decide. Okay, so we're going to go through the 4 parts of the general rule and analyze those, and then we'll analyze the exception. First off, was there a violation? Here, it appears that the landlord did violate the statute, which requires the landlord, the owner of the apartments, to keep in good repair the apartment and every part thereof. I've thrown in a lot of little quotes there to show off that, yes, I really did read the statute. The furnace was part of the apartment building, owned by landlord, and he failed to correct the problem. So it sounds like he didn't keep in good repair every part of the apartment. It's quick, it's 2 sentences, but it was violated, and that gives you some points for that. Next question, well, okay, he violated the statute, but was it excused? Well, we don't really have much facts in the way of excuse, but we do know that the landlord did a poor job of repairing it 3 times. So we can use that to argue that the violation was unexcused. So we can say landlord has been given notice of the problems with the furnace on 3 earlier occasions, yet each time he only made temporary repairs. Thus, he had no excuse for failing to permanently fix the furnace, or none that we're aware of anyway. Okay, so unexcused, violation of the statute. Now we dive into what the statute was intended to do. So first we're going to talk about whether the statute was intended to protect people in the same class as nephew. What I wrote is that the statute was likely intended to protect tenants and visitors of apartments from suffering harm or inconvenience due to clogged pipes, broken air conditioners, and other building problems. I don't know for sure why the statute was passed, but that's my best guess as to why we would have a statute that says you have to keep apartments in good repair. It's probably because landlords have a lot of power and tenants, depending on the market, usually don't have as much power, so they pass this statute to make sure landlords are keeping things in good repair. Perhaps it is because the warranty of habitability is too much work for a tenant to follow through with, too risky for a tenant. I don't know. But anyway, that's my best guess as to why the statute was passed. And then I say, even though nephew was not a tenant of the apartment, he was a guest of the tenant, and therefore within the class of persons the statute was designed to protect. You could make an argument that the statute was designed just to protect tenants and not to protect guests, but I think it's probably designed to protect both, but it's arguable. Okay, next question goes to the second part of statutory purpose. Now we need to look at whether nephews suffered the type of harm that the statute was intended to prevent. So certainly, if we were wanting to keep every part of the apartment in good working order, one of the things we want to prevent is loss of hot water. So it does sound like that's the type of harm. But when you think about it, the harm that nephew suffered was not a lack of hot water. It was having hot water, boiling water, spilled on him. So you can argue that it's not clear that the accident, which is burns due to a collision, is within the category of harms the statute was designed to protect against. When the legislature was drafting the statute, were they thinking, okay, we want to make sure apartments are in good repair because when they're not, people boil water and might spill it on someone? I don't know, that seems a little far-fetched. So I said, no, it's probably not within the class of harms that the statute was intended to prevent. Okay, then there's the exception that we talked about, where when a statute is too vague, then it cannot be used to support negligence per se. Here, arguably at least, the statute's too vague to be reasonable. To be the basis for negligence per se. Simply saying that things need to be kept in good repair is just a general principle. It's not specific enough. In fact, it sounds very much like the case we discussed in class, which said that vehicles need to be kept in good repair. And the court held that was too vague. Good repair, what does that mean? So the statute doesn't define what good repair requires or provide a standard by which the conduct can be measured. It could be a burned out light bulb or, maybe the roof caving in. It's such a broad spectrum, it's so ill-defined that arguably this statute doesn't support the use of negligence per se. Then you reach a conclusion. It's always nice if your conclusion sums up what you just said, especially if you've been through 4 different elements plus an exception. Thus, given the vagueness of the statute and the type of accident that occurred, nephew will probably not be able to establish negligence per se. So we've gone through all of that, and we got to no negligence per se. Normally, what you would be dying to do would be to do a duty and breach analysis. You'd try to see, okay, did the landlord owe a duty to nephew, and did the landlord breach that duty? And there's some good arguments that can be made that the landlord owed a duty, certainly to the tenant through a special relationship, and maybe nephew was a foreseeable victim. Maybe not. That's a little bit tougher. Did he breach that duty? Well, he certainly didn't keep the apartment in good repair. What could he have done differently? I mean, he ordered the parts. Maybe he could have warned the tenant not to boil water or given the tenant some other means of keeping the place warm. And especially if the landlord knew about nephew staying there, then you have a better argument for breach. The problem is with all of this is there's not enough time. So as much as you'd like to go on and analyze duty and breach, you probably don't have time to do it. So I would recommend moving on and going on to contributory negligence, because it is better to hit all the issues, all the major issues, than to hit some major issues and all the minor ones. Okay, so now we're on to contributory negligence. This is where basically the best offense is a good defense, or the best defense is a good offense, something like that, where basically the defendant's saying, hey, but the plaintiff was negligent too. Okay, so we're going to have a general rule for contributory negligence, which is that if plaintiff's injuries are due in whole or in part to plaintiff's failure to use reasonable care, the plaintiff is considered contributory negligent. Well, that's kind of circular. They're contributory negligence if they're contributory negligent. What does that mean? So it's good to put it in a definition. Under modern comparative negligence, so contributory negligence is the old rule. Under modern comparative negligence, the jury compares the plaintiff's negligence with the defendant's negligence and apportions liability between them. Now, where do we go next? Well, before we can figure out whether the plaintiff was negligent, we got to know what standard the plaintiff is going to be held to. Now, why don't you have to do duty with the plaintiff? Usually people owe a duty to themselves, and so usually analysis will skip over talking about duty when you're using contributory negligence. I've seen a few essays that do include it, which just seems odd to me, because of course you have a duty to use reasonable care, not to create risks to yourself. Okay, so we already gave the general standard for negligence. A person acts negligently if the person doesn't exercise reasonable care under all the circumstances. So you don't need to say that again. You can go right into the exception, which is the child standard. A child will be held to the standard of a reasonable person of like age, intelligence, and experiences under like circumstances. There are some exceptions to this, but since the exceptions don't come up in the fact scenario we're talking about, you don't want to give the rules for those exceptions because you don't have a lot of time. Okay, so the jury is going to use the child standard, and you can do some just common sense analysis here. Because it's a child and children aren't really cost-benefit analyzers, I'm not sure a hand analysis is completely appropriate here. You kind of just need to use common sense. So you can compare. A reasonable adult would probably recognize that if you run out into the hall after a ball without looking around you, that there's foreseeable risks of a collision. A normal toddler, I can tell you from personal experience, does not have any idea that such risks exist at all. Arguably, a reasonable adolescent could foresee some of these risks. Nephew is 8 years old, between a toddler and adolescent, so, you know, a little older than a toddler, but I have an almost 8-year-old and I see her run into things all the time. So I think a jury probably would not find that nephew's conduct was negligent, but there's a chance that they could. Then in a conclusion you can say, going back to comparative negligence, even if the jury finds nephew violated the standard, he could still recover, although his damages would be reduced in comparison to tenant's negligence. And there you have it, the entire bar essay in a nutshell. So that's a lot to do in 30 minutes, and it's awfully hard to do it if you don't have the rules down pat beforehand and are able to bust out the analysis quickly without stopping and pondering. That's something that you get better at the more of these you do, which is why we are having you have so many opportunities to do bar essays. You don't want to wait until your third year in order to start writing quickly and thinking fast on your feet, because you want to be able to pass the bar, and that's a skill that takes more than a few months to develop. It's something that takes a lot of time to develop. So this is your way of breaking into developing those skills. You might notice that I use some very pretty pictures in this video. The credit for those goes to the copyright owners, and there's a very cool thing called Creative Commons, which makes it possible for photographers and artists to share their work and let other people use their work, yet still retain copyright to it. And it's called Creative Commons, which has a series of licenses, and it's a very good thing. So thank goodness for Creative Commons, otherwise this video would be so much more boring. So thank you for spending this time with me. I feel like I should break into song for something from Mr. Rogers, but I won't. And if you have questions, please talk to me, talk to a TA. Don't go do a retake until you're ready. Get ready to do the retake if you need to retake it, and look through your essay, each part. You can watch this video as many times as you like, but seriously, you want to go through your essay carefully and say, did I do this? Did I do that? And I think that will help you to be able to improve not only this essay, but all your essays that you ever write for the rest of your life. All right, thanks.